Welcome everyone to today's program. As Harry mentioned, we're going to be talking about advanced directives. Now, sometimes you have patients and just maybe your family members, this is a topic they don't want to talk about because it does indicate that at some point in time we are going to pass away. However, what we also want to recognize is that patients, everyone, wants to have a say in what happens to them and with them as they near the end of their life. What care do they want? What care do they not want? And that's why it's so crucial for those conversations in general to occur. And especially important for healthcare providers to know, what do you want if that time comes when we have to make those very hard, gut-wrenching at times decisions. So that's why we're having this conversation today amongst ourselves. So why are we having this conversation today? What is so important about advanced directives? Well, as you see from this article, this was granted 2017, but this still continues. 2 out of 3 adults do not have advanced directives. I'm talking adults of any age. I'm talking them from 19 all the way up to 109. They don't have this crucial information that their caregivers and their loved ones need to know. Advanced directives are governed according to state laws, federal laws, CMS, and Joint Commission. Those are just some of the items. Now, state and federal law, that will be the backing by which you have to abide by it. That, in other words, this is what the law says you have to do. Now, there are exceptions, and that is the conscious objector. We're going to talk about all of these during today's program. And advanced directives cover a whole host of different types of documents. It's not just one. It can be a living will. Can be an advanced directive, can be a combination of forms that compose and make up an advanced directive. Organ donor card is a form of advanced directive, as is a DNR order. There's also visitation advanced directive. There's psychiatric advanced directives. All of these are types of advanced directives. The conversation that we have with our parents and our patients and our loved ones, they come under many different requirements. But as far as patients, it's the physician's responsibility to give patients information on what interventions, what medical care they want as they near the end of their life. Now, the asterisks on here, and as you see it throughout this program, that means there is a reference in the appendix for you. I didn't want to clog up the PowerPoint by showing you all of the various and multitude of examples. I do have some in here. But again, you see an asterisk, look to the appendix. Well, you need to have that conversation, or should have that conversation. What's the code status, and especially on all admitted patients? If something happens to you, do you want to be resuscitated? Palliative care departments are excellent at this. What they have found is that when you do have palliative care, whether it's an individual, a committee, or even a whole department, there's fewer ICU admissions, fewer utilization of ventilators. I'm not saying that's bad. I'm not saying in a morose kind of way, but rather the people have a right to have their wishes heard, and we're following them. And we're really respecting what those decisions are. We need to talk to patients about how they want to die. Again, that's a very tough conversation, and a lot of people don't want to have it. We can't force it on them. We just have to make it available to them. And there are multiple resources on advanced care planning. I want to point out this isn't just limited to the elderly, because there are some very young patients who, even though they're young, they have comorbidities and situations that they've already decided how they want to have their life, as short as it may be, how they want it to end. Now, I'm not talking assisted suicide. I'm not talking that here. I'm talking advanced care planning. There are multiple toolkits, as I mentioned. Crystal is one of them. And this helps to identify that actual patient who is dying. They're in that final processes. How you help develop that tool to identify those patients and make their wishes known. CMS themselves have a form and a process to help with hospice patients. I've included the internet link on most of these resources, so you can go right to it and pick it up. I would type in any of the email addresses or any of the internet links, only because if you try to copy paste Sometimes the search engines don't like it and won't recognize it. That's why if you type it in, it goes a lot easier and a lot better. You'll have a lot better success. So what would you do if you saw this on a patient? I'm going to give you a little scenario with this patient. This patient was found down outside, no one around him, unattended. And so, as people usually do, they call 911, EMS arrives, and according to what they are required to do, EMS gets the patient in, brings them in, they pull back the shirt, and this is what they see. Do not resuscitate. That reference was actually tattooed onto this man's chest. What about case law? And we're going to come back to that case. Don't worry about that. As far as case law, there are multiple cases related to advanced directives. For example, look at this patient here on this slide. This is slide number 13. He has a whole host of items going on with him. He is intubated. He is in a sedation-induced coma. His eyes are concealed or they're taped. He's on multiple IV medications. This man is not in good shape, let's face it. Now, if he were of a certain age or maybe a certain medical condition, do you believe he would have had some information or something that he would not want done to him if he had the decision capability to be made? Overall, a mentally competent individual, an adult usually, has the legal right to refuse treatment. They don't have to take the care. They don't have to. If they're competent and they're of a certain age according to your state law, they can say, no, I do not want that done. And okay, we may not agree with it. We may not like it, but we have to respect it. We have to abide by it. Joint Commission, CMS, they require hospitals to honor those rights to refuse treatment. And by the way, this must be an educated or informed right. They have to know what are the risks, what are the benefits, what are the complications, the outcomes. Well, the outcome, of course, will probably be death. But they have to know what are those risks if they don't accept our treatment. Two major cases, Quinlan and Quinlan, they helped establish the right to refuse life-sustaining treatment. And it broadened that law to include non-competent patients. Now, the earlier cases before Quinlan and before Quinlan, there had to be a court-appointed guardian that would step into the shoes of the patient and make those decisions. With Quinlan, this was the first case to ever mention the condition known as a permanent vegetative state. Ms. Quinlan took an overdose and arrested at age 21. And so for the next multiple years, she was removed from the ventilator. And they thought at that time, okay, this is it. Well, she didn't die. Karen started to breathe. And in fact, it was not until 1985, 9 years later, after she had been taken off the ventilator, that Ms. Quinlan did die. And she died as a result of pneumonia. I've included the case reference in this particular one. But again, even after being off the ventilator for 9 years, she was in this persistent vegetative state until the pneumonia took her life. Nancy Beth Cruzon was a little different. She was still a very young woman, 25 years old. She was in a rollover accident. She was found 35 feet from her vehicle in a ditch and not breathing by the time EMS arrived. They believe she had been without oxygen for at least 15 minutes, maybe longer. They couldn't fully establish it. Over the time, Mary Beth was in the hospital. She had, of course, she was on a ventilator. She had the feeding tube inserted. She was able to come off the ventilator. But the question is, that feeding tube, that's life-sustaining treatment. Now, the family had requested the tube be removed after 5 years. But this case didn't end at 5 years. Teresa Chavio, another case, another young lady. She had a potassium imbalance. She was quite the dieter and was a long-term runner, etc. Age 27, she arrested because of the potassium imbalance. She was in a persistent vegetative state since 1990. 6 years later, her then husband petitioned to have that feeding tube removed. Again, this is life-sustaining treatment. Her parents fought it and fought it, saying, no, that's our daughter, we want her to live. over another 9 years. So now we're up to 15 years since this occurred. The court finally said, you know what, husband, you are right. Based on all the information that came out, all the testimony, all the comments, the court agreed with the husband and said, you know what, okay, maybe it is time. So it wasn't until 2005 that that feeding tube was finally removed. Upon her death, they did, of course, do the post, and this is what they found. The CT on the left, the brain, that's a normal brain. That's yours and my brain. On the right was Teresa's in 2002. And you can see there's been a massive loss of brain tissue. That black area, nothing but hydrocephalus. Her brain was half the weight of a normal brain.